Hello, and welcome to this webinar on assessing capacity. I'm Leo Briggs, and I'm Deputy Head of the DDU. I've been a dentist for quite a long time now. I've worked in community, I've worked in general practice. I'm a specialist in periodontics, and I've been at the DDU now for 20 years in August. So I've had a fair bit of both the dento-legal issues around assessing capacity, but also, especially in my time when working in community, practical experience of assessing capacity for patients. So that's a little bit about my background. So what I wanted to do is I wanted to just start with some of the real basics. And two of the principles of medical ethics are, first, autonomy. We need to respect patient autonomy. Patients will make their own decisions based on evidence. We have to respect that decision, even if we think it's wrong. And then the second one of beneficence, and I'm glad I got that word out right, I often don't, which is promoting what we think is best for the patient. So it's about doing good. A patient may choose a course of action that is not in their best interests, and that can set these two sort of at odds with each other. But the basic principle is that we should only do things which we think are going to be beneficial for our patients. We should never do something just because a patient wants it and if we think it's not appropriate. And patients having the choice is an important part of capacity and assessing capacity to consent. So going to some of the basic principles of consent, it's the expressed or implied permission of a patient to undergo dental examination, investigations, treatment. Implied consent means that they haven't actually said, yes, I allow you to do this. And you can only rely on implied consent for an examination. Everything else, the patient should positively say that they agree to you doing it. Doesn't mean they're happy for you to do it, but that they agree to it. The numbers of patients who are not happy about having any treatment done is quite phenomenal. But they still consent to it and they agree to it being done. So some practical advice about consent. I think sometimes people think of it as a standalone subject, as a bit of a theoretical subject almost, separate from the care that's being provided. Oh, I must get consent. Oh, and think of it that way. And my advice is don't do that. My advice is that it is part and parcel of the care that you're providing a patient. It is not a one-off procedure. It's something which is ongoing. So if you are good at diagnosing and treatment planning patients, and you are good at communicating with patients, you basically have their consent. If they've agreed to it when you've explained all of the options to them. As I said, implied consent can only be relied on for the examination. Expressed consent can be oral, and the vast majority of consent is oral. You don't need to get written consent. The only times that that's mandatory is when you are providing treatment under sedation or under general anaesthetic. It can not be recorded in the records. We would always advise that it is recorded in the records. But oral consent is absolutely fine for the vast majority of dental treatment. A consent form does not prove that you've got consent. So my advice always is not to worry chasing your tail trying to get the form signed. The more important thing is that you have that discussion with the patient. that the patient truly understands the advantages and the disadvantages of the treatment, and also the consequences. It's really important that patients understand what might happen if something doesn't go according to plan, so the consequences. So have those discussions with the patient and spend your time having those discussions rather than trying to get them to sign a form. Forms can help to show that you tried to get consent, but they don't actually prove it. And people sometimes ask me, how do I make myself bulletproof? Well, the short answer is you don't make yourself bulletproof. So work on that communication, that discussion, that clear information to patients, and that will put you in the best possible place. And then accurate records. It's a fundamental principle of good practice that consent is obtained. If you don't have it, you might find that you are sued because you haven't got consent, and you might face criticism if from a regulator if you haven't got consent. So it's important to make sure that you do have the consent of the patient. And there is some evidence that patients are less likely to litigate if they've been fully involved in the decision making, even when the worst case scenarios happen. If a patient has been warned that it could happen, and it does happen, they're less likely to panic if that happens, so you're less likely to get the out of hours call about it. Also, they're thinking, yeah, I was told about this, so they're less likely to get annoyed, upset, frustrated about it. So it just makes good practical sense to do this. There are three basic principles of consent. The first one is competency. The patient must be able to make the decision. It must be voluntary, and they must have sufficient information. And competency, the ability, the capacity to be able to consent, is what I'm going to be focusing on in this webinar. And you must not do any treatment if a competent patient has refused to consent to the treatment. If somebody tells you to stop, they have withdrawn their consent. If you've said, if you lift your hand up, I'll stop, that's the same. So you must stop treatment, and you must not do any treatment if they refuse to consent to it. You must not do treatment which you do not think is in the best interests of the patient, and I discussed this earlier under the basic principles of medical ethics. Even when the patient wants you to do it. So have that moral compass. Think, is this appropriate for this patient? If not, don't go ahead with it. The consent process in this country has been evolving over the last century and this century. The Bolam standard, the Bolam test, is something that's often spoken about. And you wouldn't be negligent if you follow practice by a responsible body of opinion. And that is still the test for negligence for the treatment, but with consent, things have moved on. It has changed. So it started changing around 1985. The House of Lords, which the Law Lords are now being replaced by the Supreme Court, but they decided that it was still what a responsible body of opinion would say was appropriate, was the test for whether you had obtained consent or not. So what we as a profession thought was the appropriate thing to tell a patient. But there was a minority decision made by one of the judges who thought it should be what a reasonable body of patients should think, and that's gained ascendancy. There were developments, including the Mental Capacity Act, which have built on that. And so, and also decisions in other jurisdictions. And so now we're at the place, and we have been since 2015 with the Montgomery judgment, that it's not, it is the patient now who decides how much information should be given to them. Now, it's sometimes patients will have what I would term buyer's regret. And they will say, well, if I had been told about that, I'd have never consented. Actually, what you need to look at is, would a reasonable patient in the same condition say that? And that's how judges would look at it, which is slightly different to that individual patient saying it. So if the patient has said, no, you cannot do it, but if the patient has said yes, and then later says, oh, if I've been told about that, I would never have agreed to it, that might not be the case. It might be judged that you actually, that you weren't negligent for the way that you dealt with the patient. So this is how the law says it. You know, would a reasonable person in the same condition attach significance to that risk? And if so, then you should warn the patient of that risk. I've just had a question, which I will try and answer. Thomas O'Connor has asked, while we're waiting, could you mention a little bit about how we can assess what a patient would be likely to attach significance to? Are we not just guessing? That's a really good question. And you're not just guessing, but you have to put yourself into the patient's shoes. You have to understand your patients. You have to know enough about your patient to then analyze the information and think about whether this would be important to that patient. So, for example, if a patient is pregnant, you need to know they're pregnant, because there are certain things that they would attach more significance to because of being pregnant. If a patient has a profession where their teeth are really important to them, so actors, musicians, etc., then and the appearance is incredibly important, then you need to think, do I tell them about this particular risk? Although it's highly unlikely to happen, would they attach more significance to it? And so that is one of the things to be thinking about. So the more you know about your patients, the more you understand, then that's important. Now I'm going to try and get one of the people in the back room here to move the slides on for me. So let's see if we can get that to happen. Right, I think I'm back in. Hopefully this will work now. Yeah, so I'll just go back to where I was before. I was talking about the test of materiality. Something else that has changed or been refined with consent is what's called McCulloch judgment. And this is fantastic news for us as a profession. It clarified whether an alternative treatment is reasonable and needs to be discussed with the patient. In the past, some people have said you must discuss every single option with a patient. I've always thought that was nonsense. If a patient comes in pain and you say, oh, I can do no treatment for you, it's frankly ludicrous that you would be expected to do that. And the McCulloch judgment confirms that. It clarified who decides whether an alternative treatment is reasonable and needs to be discussed with the patient. And it is us, it is the profession. We cannot be required to advise patients about treatments which we do not think are reasonable. So what you need to do is you need to have what you think is ideal, what you think are appropriate compromise treatments, and you discuss those with the patient. Those treatments which theoretically could be done, but you do not think are reasonable, you do not need to discuss with the patient. Once you've decided on the treatment options that are reasonable, you do need to provide all the information about those to the patient, and that's the important way to think of it. So discuss treatment with your patients rather than presenting them with the treatment option. Discuss those reasonable alternatives. If it's appropriate, you discuss the having no treatment, but you must explain the consequences of that to the patient so that they can make a fully informed choice. You don't have to mention absolutely every single advantage and disadvantage. You need to think, what would a reasonable person in that patient's position want to know? So putting yourself into the patient's shoes. Make good records. I say full notes, but it should really be good notes. They don't have to be hugely detailed, and some of the records we see sometimes are real essays. It doesn't need to be like that. It can be good, brief, but full notes. When I say full, all the options, so just a little heading saying which ones you discussed. And they're more than just a consent form, and be really careful with auto notes. We see so many that are not amended that it brings into question all your record keeping, and people will ask, did that actually happen, or did you just bang in the auto note? So be really careful about auto notes. Try and make sure there's enough time set aside. That's always easier said than done. But it is important to try and have those good discussions with patients and focus on the individual patient. That's really important. So the more you know about the patient, the better. Obviously, new patients, that's much more difficult. Urgent care, it's difficult, but that will be taken into consideration always if there are any questions asked. But just make sure that you have focused on the individual patient. And it's not just the percentages, the likely chance of this happen, it's the consequences. For example, if you can say that 98% of your implants work, what are the consequences if that patient comes into the 3% that fail? That's important, because for that patient, it's a 100% failure, isn't it? So, it's not just the percentages and the stats. It's also thinking about the consequences for that patient. And then patient understanding. Have they taken on board the information? And again, this relates very much to the capacity to consent as well. Again, just do everything you can. Use all your soft skills, all your listening skills, all your communication skills to try and assess whether the patient has understood. So on to patients who might lack capacity. It's important to remember that it's not a set thing. Capacity to consent can vary. It can vary with time. Some patients are better at some times of the day than others. Some patients might have something where they get worse and then start to get better. So it's a fluctuating thing to assess. And it's also the complexity of the particular procedure or particular decision that you need to be thinking about. Some patients will have capacity for making more simple decisions and not the capacity for the more complex ones. So you've got to be thinking about all of those things and weighing it up. If in doubt, think about getting a second opinion from another dental professional, just to look at the necessity for the treatment, and then also seek to involve those involved in the patient's care. Now, it might be that a patient does have the capacity to consent, but they're starting to get a bit confused. They're starting to have things that they're finding more difficult to grapple with. You can ask them if they want to involve others, and if they do, that is fantastic, because then you can start to build that relationship with the carers, and if the patient gets gradually declines, that their ability to consent declines, then the carer can start to gradually step in. It's similar to a parent-child relationship in reverse. Very, very young children, the parents are making all the decisions. As children mature, they gradually start taking more responsibility for their own lives, for their own decisions, and the parents need to reduce the amount of involvement they have in that. And it can be the opposite with somebody who, for example, has dementia. So if you have the ability to start to involve those carers early on, it can be enormously helpful. Under the Mental Capacity Act, and I appreciate that there are different acts in Scotland and Northern Ireland, but the same basic sort of principles apply. So I think it's important to think about that. But the starting point is that you must assume that someone who is 16 or older has the ability, and I prefer the word ability to capacity, to consent, unless it is established that they lack it. So it's that assume they do until you've proved that they don't. And then there are 5 principles that you need to be aware of in the Mental Capacity Act. The first one is a person must be assumed to have capacity until it's established that they lack it, which I've already covered. The second one is you do not treat someone as unable to make a decision unless all practical steps have been taken to help them make the decision. Now that's onerous. We have to think about absolutely everything to try and help them make the decision. And only when that's failed can you say that they lack capacity. Someone is not to be treated as unable to make a decision simply because they make an unwise decision. As patients, we are allowed to make silly decisions. It's our right as a patient, and you can't assume that someone lacks capacity just because they've done it. I know that sounds easy in principle, but it can start to get difficult, again, with patients with dementia, with patients who've got a medical condition that's affecting their ability to consent. And the people at the extremes are always the easy decisions to make. They clearly have capacity, or they clearly don't, or they clearly cannot communicate it. It's the ones in the middle which are always the difficult ones to make the decisions about. So, principle number 4, if you make a decision, if you do something on or behalf of the person who lacks capacity, you must be doing what is in their best interests. And then the 5th one, before it's done, you have to think about, can it be done in a less restrictive way? In dentistry, that's not a really common problem to face. The most common one, I guess, is for people who are having to decide whether a patient who really lacks capacity and lacks cooperation needs treatment under general anaesthetic. So can it be done in another way which is less restrictive, is the basic principle that you need to be thinking about. So deciding if someone lacks capacity, 2 stages to this. The first one is, do they have an impairment of the mind or brain, or is there a disturbance affecting the way their mind or brain works? So that's the first thing. is there an impairment or is there a disturbance? It can be temporary, it can be permanent, doesn't matter, but that's the first thing to decide. The second thing is, does this impairment or disturbance mean the person is unable to make the decision in question at the time it needs to be made? So if the answer to the first stage is yes, then you go on to, is this affecting their ability to be able to make the decision at the time it needs to be made? Now that implies that if it can be delayed, if they will be able to regain capacity later, do so. And again, in dentistry, sometimes you can do that, sometimes you can't. It depends on the particular item of care that you need to be providing or want to be providing for that patient. So then, can the patient understand the information? Can they retain it? So can they keep it in their mind long enough to weigh it up? And then can they communicate their decision? So those are the things that you need to think about. Can they understand it? Can they retain it for long enough to weigh it up and then communicate the decision? Again, a lot of patients with dementia will be able to do all those things. The difficulty is that later they've forgotten that they did it, but they are able to retain it for sufficient length of time to make the decision at the time. Keep careful notes if you have got a patient who has dementia about the steps that you took to check that they understood it, that they retained it, they weighed it up, and they communicated it. If those criteria are not met, then there is the inability to take the decision. Again, you can't make assumptions that people lack capacity just because of their age, their appearance, any aspect of their behavior, which leads you to make assumptions. You need to be able to prove it, that they lack capacity. When it comes to helping with assistance to make decisions, there's a supporting document that goes alongside the legislation, very lengthy, but some of the things to think about are using different forms of communication, providing information in a more accessible form, keeping it simple if you're using written language. If there's a medical condition that's affecting their capacity, getting that treated. So if there is a mental health issue, encouraging them to get care for that. It can be something like diabetes, which can affect people's capacity to consent. Having those discussions, getting it under control before moving on with things. And then having a structured program to improve the capacity to make particular decisions. Quite frankly, as dental professionals, I don't think that we are have been trained, or very few of us have been trained to work out those structured programs. That's where you want to involve other healthcare professionals. Can they do something? Can they help? And that's where you want really multidisciplinary approach to this, because I never been trained to do something like that. There might be a few people who are specialists in special care dentistry who do that, but really it's not mainstream for dental professionals to be able to do that. So deciding what is in the patient's best interest, there's no definition of this, but legally there should be only one course of action that we take. And it's not just limited to the dental care, the medical care. You need to take into account welfare, social, emotional, psychological, and other interests. Again, that's hard. We've not really been trained to assess that. But it comes back to the more you know about your patients, the more you have understood them, the better able you are to take into account those sorts of factors. Lasting powers of attorney. These, under the Mental Capacity Act, replaced the old enduring power of attorney. The enduring power of attorney, enduring power of attorney could only be made for financial decisions. But a lasting power of attorney, you can have two different ones. There can be one for health and welfare decisions and one for financial decisions. If someone says, I've got lasting power of attorney over my relative or friend or whatever, you need to check that it is one for health and welfare decisions, not one for financial decisions, because it might not apply. So that's important. There are also strict rules about them being registered, and they have to have been stamped, etc. So just because one's written doesn't mean it's actually in force and has been appropriately registered. So if you're faced with one of these situations, get in touch with your defence organisation. All of you who are DDU members, get in touch with us. We can look at that and advise you about it. It's just, don't worry about saying to someone, look, I need to just double check all of this. Then advanced decisions. Those are living wills that patients can make. A patient can make an advanced decision to refuse treatment, which can come into force when they lack capacity. So, I could decide now that I'm going to make an advanced decision so that if I later lack capacity to consent, that would apply. You cannot make an advanced decision to demand a specific type of treatment. So, for example, I couldn't say, I want to have implants if my teeth are lost. What I could do is I could say, I do not want to have dentures if my teeth are lost. So I can refuse, but I can't demand. An advanced decision can be written or verbal. It must state precisely what treatment is being refused. It's not just a general, I don't want any care if I get dementia. It must be really precise. That's important. A written statement is different. This is requesting that certain treatment or care and things should be considered. It's not legally binding. So that is just if this happens, this is what I'd like you to think about doing for me, is the way of thinking of a written statement. It can be much broader than the advanced decision and is not legally binding. The life-sustaining treatment, again, hopefully this is the vast majority of times it's beyond the remit of dentists and dental care professionals. But much more stringent requirements apply if advanced decision involves that refusal. And urgent treatment, the need for urgent treatment outweighs the need to find out about advanced decisions. So basically, if there is a medical emergency, get on and treat it. Don't be looking around for the advanced decision. Just get on and do that urgent treatment if there's a medical emergency. And liability. If you provide any treatment for a patient who lacks capacity and you have established that they lack capacity and the treatment is in the best interests, it is as if they consented. So you won't be sued for lack of consent. It doesn't mean that the treatment can fall below the standard expected of you. You could still be sued for poor quality of treatment, but you wouldn't be able to be sued for a lack of consent. So if you've decided that the patient doesn't have the capacity to consent, you can give treatment if it is in their best interests, unless there's an advanced decision or the patient is involved in research. Again, with both of those, incredibly, vanishingly rare for those to apply to the dental treatment. So what does this mean when working? It means you need to be able to justify why you have decided the person cannot make the decision. So you need to be able to explain why you've reached that, why you have decided that. And it's the individual decision in question. As I've said before, some decisions are more straightforward, some are more complex. The capacity may vary according to the complexity of the decision, and the patient's capacity itself might fluctuate with time. So all of that needs to be thrown into your decision-making process. How do you decide what is in the best interests? You know, as I've said, there's only one course of treatment. So just remember that when thinking about what is actually best for this patient. There's a checklist of matters which must be considered by anyone who needs to decide. It's a starting point. So just think about the following steps. Will they have capacity at some point in the future? So that's the first thing to think about. If yes, when? Encourage the patient to participate as fully as possible in any decision or act, and then encourage the patient to improve their ability to participate. So it's involving the patient as much as possible. Where the decision involves life-sustaining treatment, you must not be motivated by a desire to bring about the death of the patient. Hopefully that would never apply to any dental setting anyway, but it's an important principle to remember. You can't be thinking, oh. So relatives need to be very aware of that, though. Consider, as far as possible, past and present wishes and feelings, relevant written statements, so take all of that into consideration. Beliefs and values that would likely to influence the patient's decision if they had capacity. You know, my beliefs and values are that I floss like hell every day. I brush my teeth meticulously. So I would want that to continue. Then take into account, and it's taking into account views of anyone named by the patient as someone to be consulted. So if they said, I'd like this person to be consulted, take that into account. People who are engaged in the care of the patient, you know, involve them, it's fine. Anyone interested in the welfare of the patient, sometimes there are relatives who are distant, so not engaged in the care of the patient, but they are interested in the welfare. Obviously, if there is someone with an appropriate lasting power of attorney, they should be consulted. And again, it's incredibly rare for this to be happening in dentistry, but if the Court of Protection has appointed a deputy, then they need to be consulted with. Then again, the decision should not be made on the basis of the patient's age, appearance, their condition, or any aspect of their behaviour which makes unjustified assumptions about them. Record keeping, the Mental Capacity Act states about the sorts of things that you must record for each decision, how it was reached, what were the reasons for reaching it, who was consulted, what factors were taken into account, and that must be in the patient's records. So again, it's quite onerous record keeping. And then really important to consider if the patient might regain capacity in the future. If it's possible to delay the treatment until then, do so. And again, make a note of that in the records. Then disputes about best interests. Again, this does sometimes arise in dentistry. And the code offers guidance on ways to settle that. So think about second opinions, holding a case conference, attempting mediation, involving an advocate to work on behalf of the patient. Ultimately, things might need to go to the Court of Protection. Again, that is quite rare in dentistry, but it sometimes happens. Sometimes around decisions for patients around the need for GA, etc. Those are the sorts of things that can sometimes happen. And ultimately, it might need to go to the court of protection. But again, as I said, it's really rare in dentistry for it to go that far. Serious medical treatment, and again, this doesn't, I can't imagine this involving dentistry. Giving of new treatment, stopping treatment already commenced, or withholding treatment where there's a fine balance between benefits and burdens of treatment. If it's decision between the choice of treatments is finely balanced and treatment is likely to have serious consequences for the patient. So it's I don't think that that's ever going to really apply in dentistry. It's things like chemotherapy, therapeutic sterilization, major surgery. It's those big things. It's not going to apply to what we do, which is great. So the Court of Protection. It's a specialist court. It was established under the Mental Capacity Act. It deals with healthcare and welfare as well as financial affairs. So like the lasting powers of attorney, it deals with the same issues, support and protection. It can decide if the person has the capacity, it can make declarations, it can appoint deputies, it can decide if a lasting power of attorney or enduring power of attorney is valid. Enduring power of attorneys for financial decisions, if they were put in place before the person lacked capacity, they signed for them to carry on rolling over, they can still apply. As I say, those are only for the financial decisions. The Court of Protection can give directions to attorneys, so tell them what they need to do, and they can remove them from being an attorney. So those are the powers of the Court of Protection. Use of restraint, it must be in the patient's best interest, must have objective reasons to justify it, must show that the patient is likely to suffer harm if it's not used, and it should be the least intrusive type. Again, the chances are that in general dental practice, you're not going to be faced with deciding to restrain a patient, because you are more likely to be referring that patient onto someone who needs a specialist in special dental care. But people working in those settings are going to be having to think about restraint and using the appropriate techniques to restrain a patient. Children. Legal age of consent is 16. And you need to think about the same sorts of things. It's, does the child have the ability to consent? So if they are under 16, they can still consent. And that's an important thing to remember. If they have sufficient maturity and they can weigh things up and communicate the decision, exactly like those over 16, they can consent. The different way of thinking of it, though, is with someone who is 16 or older, you think they can consent, can't they? Whereas with a child, it's turning around to the can they consent. So that's the way to be thinking of it. But a child can consent, but it's usually best to involve parents whenever possible. There might be situations where you do need to ask a child, can I discuss this with your parent? Again, with dental treatment, it's usually not too much of an issue, but yeah, it is something to bear in mind. All of this comes down to communication, communicating effectively with patients. So looking at those GDC standards, I've highlighted the not using professional jargon and acronyms. That's so important. And it's really hard because we're using those terms, we're using those words day in, day out. Everyone in dentistry knows what a VPE is. So, it's just we forget that patients don't know what it means. We all know what composite is. A patient might not know what that word means. We forget that. So be really aware of that when you are discussing things with patients. Again, GDC standards, these are pretty straightforward, aren't they? We need to satisfy ourselves that the patient has understood the information, not just taken on board the information, actually understood it, and make sure they have enough information and enough time to ask questions and make a decision. Those, I really like those because they put into plain English all of that legal jargon that I've been discussing. Now, I know these sorts of things are often difficult. It sounds easy in theory, but the actual practical interpretation of them when it comes to an individual patient that you are treating or caring for, it can be that much more difficult. So if you've got an issue like that, just give us a call. That's what we are here for. We are here to help our members. So just give us a call. It is 24 hours a day, 7 days a week. Best time to call is between 8 a.m. and 6 p.m. because that's when the advice lines are fully staffed. Out of hours, it might save that for urgent things because it will take longer for us to get back to you. It is 365 days a year, and leap years, you get the extra day as well. So just give us a call. And then, as you know, we are led by dentists. We are here for dentists. So just remember that. Now, there's a little bit of information now about our new education program, which is launching in August. So if you want to take a picture of that QR code, you can do. The slides will also be available on demand. I think it's on YouTube. Oh, I should know that, shouldn't I? So yes, but it is an exciting offer that we are launching in August for our dentist members. And so there's a little bit more information about it. And that's basically it. So I'll leave that up. That's just got the membership numbers about how to contact us. So what I'm going to move on to now, unfortunately, we haven't got that much time because of the technical issues, and I'm sorry about that. But I'll just go through one or two of these questions. So can disputes be from abroad? If there's no immediate family in the UK, who can make property and financial and welfare decisions on behalf of the patient? Really good question. If the attorney is abroad, they can do it. So I think the thing to do is to make sure that they've got an appropriate lasting power of attorney. If they haven't got a lasting power of attorney, it might be appropriate to involve them in the care, in the decision making, but they can't order that it's done. So I think that's the important thing to think about, the difference between whether someone is an attorney or whether they are someone to involve in decision making. And then I've asked, please, what about case of Gillick competence? Well, yeah, Gillick competence is what I was talking about with the children. It was one of those landmark decisions. Victoria Gillick didn't like her name being used with it, but quite frankly, she shouldn't have taken the case forward, so she didn't want her name attached to it. The case was around children, so under 16s, being given contraceptive advice and care without parents knowing about it. it was one of those cases that as it toed and fro through the courts, the decisions bounced one way then the other. But the ultimate decision was that if the child is mature enough to weigh up the information and retain it and make a decision, then they can consent to that decision, and they have the right to not involve their parents, basically. So it means that the parents do not have an automatic right to know about the health of their child, is in essence what it is. And then there's a question there about if your patient has a DNR and has evidence this and a copy of the dental records, and the patient goes into cardiac arrest, should you start CPD or stand back and watch them die? Very hard for the team. I would say do not stand back and watch them die. You start the CPR. You don't know whether they would have changed their mind, whether they revoked that decision. So you start that. It will be for the hospital that they go to make those decisions about further care. Do not resuscitate in a high street setting. I would say don't worry about it. Just get on and do it. And I hope that's helped. Thank you, everyone. And as I said, any questions at all, just get in touch with the DDU.